And it is yet another anniversary that I'll bring to you in more personal terms, because I would submit to you that unless you're celebrating an anniversary, a birthday, a wedding date of some kind, you might not remember exactly what you were doing 25 years ago this last week. I do. I do, because it's recorded in the Oregon reports, the very first pages of volume 304 of the Oregon Supreme Court recordings, which celebrated that day, September 16th in this case, 1987, the bicentennial of the Constitution of the United States. I was invited to speak, but I remember that day in part because it wasn't clear I could make the day work. I'd agreed to appear at Constitution Day festivities of Rhododendron Elementary School in Florence, Oregon. And so I remember very distinctly getting it up at dawn, flying in a small private plane to Rhododendron School, and being greeted by students in colonial and early statehood costumes, and giving a little lecture on the Constitution. And I asked these two questions, being the law professor that I was. I said, first of all, what is a Constitution? Without hesitation, fifth grader Kevin Scott raised his hand and he said, it's our first law. That was really quite good, even profound. Well, I asked the second question, which is, what does it do? A third grader, whose name was David Polachek, said, it protects us. With those 7 words, I was well armed to fly then in this lovely private plane in a lovely Oregon September day, all up the Oregon coastline, land in Salem, and at least barely make the festivities in the Oregon Supreme Court, where members of us who were then state officers gave observations and declamations about the bicentennial of the Constitution. And in that case, I happened to speak and give brief portraits of the slightly more than 10% of the founding generation, the 55 people who were at the convention in Philadelphia, who had been or were to be state attorneys general. That was my speech hook, if you will. It turned out that they actually had quite a distinguished reputation. They weren't a Madison, they weren't a Franklin, they didn't preside as a Washington, but it included people such as John Rutledge, who headed the Committee of the Tail, very key player in drafting the final Constitution. So that's my flashback today, is to somehow move these 3 anniversary dates together in some ways that are meaningful. To give a little bit of explanation, reflection, and prospects of the Constitution, and in view of the title that I was asked by Ofer to give my remarks, to talk about some of the traps, the problems, missed opportunities, as well as celebratory moments of this Constitution. And I will be followed, I believe, by Professor Ramon, who will talk more specifically about a couple of areas that I think are of particularly current and interesting relevance, so that he will do that, certainly, at least if we have time. No surprise, probably, that the Constitution has resulted in 2 developments that have been noted practically from the beginning of the Republic. The first is de Tocqueville's observation in Democracy of America, written in 1832, that Americans have this unusual tendency to shift their political disputes into legal conflicts. An unusually strong proclivity to, if you will, constitutionalize political disputes. And the second, and perhaps not surprising, and maybe there's hyperbole involved in my claim now, but the creation or evolution probably of the single most powerful and maybe even secret court in the history of the world, at least the world that we know it. So with that having been said, some quick observations. And that is that we have a Constitution which is the product of conflict and of a very rich history. And in fact, one cannot understand the Constitution, I think, without understanding the conflicts of which it was born and the political tradition to which it is heir. And that's actually quite an ancient political tradition. The British Constitution is something that people in the United Kingdom are well aware of. It isn't written at all. But people such as Walter Bagehot of the 19th century wrote volumes about the British Constitution. And in fact, if you're talked to any knowledgeable person who's a British citizen, he or she will know quite well and be able to describe to you what it is, which is an understood relationship of political institutions among each other, and that gives legitimacy and power to the government. So constitutions do not have to be written to be effective. And there's something about that, I think, that even reflects adversely on the notion that a constitution has to be textually precise in order to be a constitution at all. The second thing that is relevant here is that there are long historical antecedents to our Constitution. Anglo-Saxon government preceding the Norman Conquest in 1066 developed consultative devices that could well have been copied or carried into community councils that gave some notion of some kind of community or legislative power beyond that of a tribal ruler. But rather more clearly, after King John's truly disastrous kingship, he was not a very good person. And understanding just how badly King John misbehaved with his barons, even to the point of abusing their wives and daughters, certainly leads to a broader, richer historical understanding of the development of the Magna Carta, from which we can trace rather directly the due process clauses of the United States Constitution. Articles 39 and 40 in the Magna Carta identify the law of the land, the notion that you have to be judged by your peers, the sense that arbitrariness is the very opposite of law, and that there is something called the law of the land. That law of the land clause is actually also in the Oregon Constitution, Article 1, Section 10. So nearly a millennium of antecedents can be traced directly from the Magna Carta into our Constitution. And of course, that wouldn't have happened without kings and wars, enormous conflicts, the glorious revolution, so to speak, of Britain, the marvelous jurisprudence of Sir Edward Coke, who transformed the law of the land clause into something that we understand, I think, more securely as the due process clause today. Let me skip my PowerPoints for a minute. I don't know that you need them. The third is that the founding generation was highly skilled, highly fluent in understanding the history that they relied on. In fact, the Constitutional Convention debates, which we know of only because of Madison's notes, it was the largest and most important secret meeting in the history of America. There was no public meetings law to be enforced. The delegates took an oath of confidentiality, and they actually even closed the windows in Constitution Hall because in a steamy hot summer, because they didn't want to be overheard by eavesdroppers outside. It was a secret meeting in all of those respects. We know it only from Madison's notes and a few other sources that have become available in more recent years. But what we do know of them is that the founders debated sometimes at a very high level. They knew the precedents from the Greek city-states, from the Roman Republic, or at least their ideas of the Roman Republic, from the Glorious Revolution. They were aware of current developments in democratization or representation in Holland and Germany, and referred to them too. So even though they were highly practical people, they were very well schooled in political theory and history, and they understood the kinds of conflicts between legislative and executive and royal power that had led to developments in England, which we then copied or tried to avoid. At that time, of course, the Articles of Confederation were in fact failed federalism, requiring a unanimous vote essentially of each of the 13 colonies then become states. And so they had a mandate of sorts to go to Philadelphia and revise the Articles of Confederation. They didn't do that. This was a political coup d'etat. Within the first few days of the convention, quite literally, the delegates from Virginia, together in a loose and not very revealed coalition with those of Pennsylvania, decided to scrap the Articles of Confederation and start all over. So that from the very beginning, ironically, they started without authority, or at least they usurped the authority that they attempted to exercise. The Constitution that emerged is, for all of the complexity and all of the now seemingly arcane, in some respects, 18th century language, a simple and, in some ways, in its architecture, majestic document. It has, in my view, three architectural principles. The first of them is the establishment but division of national power into 3 institutions. We call that the separation of powers. But the word separation of powers do not appear in the Constitution at all. That's how we describe it. But those aren't words that you'll find any place in the constitutional text. And the separation of powers is found by the establishment in the first 3 articles of the Constitution, 3 separate institutions. The first, Article 1, is the legislative power. They all begin with the same 4 or 5 words. The legislative power is vested. Article 2, the executive power is vested or shall be vested. Article 3, the judicial power shall be vested. Now, a mechanistic understanding of the separation of powers would say these powers are all distinct. In fact, you can't make the Constitution work at all if those powers are totally distinct. So, more properly considered in my view, is that the separation of powers describes not distinct powers, but separated institutions that share overlapping powers. Otherwise, you can't have a cooperative, even though conflicting, national power established, in my view, at all. Now, what's astonishing in retrospect is that the executive power bears no relationship to the power of the presidency as we know it in the late 20th and early 21st century. There are only a few things that are said in Article 2 about what it is that the president will do. We know that there may be something called the executive power because it's vested in the President of the United States. But what is executive power? The President's made commander-in-chief. You may recall that enormous volumes have been written and argued about whether or not extreme rendition and other conduct of people under the direction of the President constitutes something that emanates from the commander-in-chief power of Article 2. The President has the power, hold your breath, to give the State of the Union. The President has the power to make reports to Congress. The President has authority to make treaties, albeit with the Congress assenting to them. He has the power to make appointments. Many of them also require congressional advice and consent. And that's sort of it. So the power exercised by the President today, ironically, comes to a significant, maybe almost exclusive degree from authority delegated by the Congress. The powers of which are described actually in Article 1. 18 different clauses. And a lot of interesting debate in the convention. The first attempt was to give the Congress rather supreme legislative power. Some of the state's writers got a little bit concerned about that, so decided to enumerate congressional powers. And they had a list of 18. But they followed it with an unenumeration, which we now know today is the necessary and proper clause. Creating ambiguity, maybe an additional separate grant of power, something that has come to be relevant in headline material as recently as the major United States Supreme Court decision on the Health Care Act just last spring. So the question is, what authority does Congress have? The answer, in my generation as constitutional law students, was a lot, maybe even plenary. And premier among them was, of course, the Commerce power, which we understand in a variety of different ways. But it was suggested that the Commerce power probably has nearly unlimited reach. But as a consequence of the new jurisprudence of at least 4 and maybe 5 members of our court, there may be a suggestion not only that the Commerce power runs out of gas, if you will, to use one metaphor, but that it might actually hit a wall, which is, of course, the second architectural principle of the United States Constitution, and that's federalism. Well, federalism isn't mentioned either in the Constitution. But what it is, of course, is the geographic dispersion of power, allocation of governmental power as between the national government of enumerated, albeit quite sweeping power, and semi-sovereign states, which exert residual authority, which have no limitations because their power is theoretically in their own jurisdictions unlimited. At least that was the 18th and 19th century view. Did the formation of the Union change all of that? It's odd, isn't it? Rhode Island never showed up. didn't go to the convention at all. Rhode Island didn't ratify the Constitution. It took less than a unanimous vote of all of the former 13 colonies to ratify the Constitution, but they said, here we are, we're all together. And in McCulloch versus Maryland in 1819, Justice Marshall took the occasion to write, not quite as an afterthought, that you can tell from the preamble. It doesn't say, we the states of the United States. It says, we the people of the United States. And Marshall and many of the founding generation took it for granted that something new was created and that the states, although they had been founding building blocks, no longer were independently sovereign or had any claim to be the source of legitimacy for the Constitution, but rather the people did. That debate remains, of course, to this day. You'll see 10th Amendment advocates, again in my day as a constitutional student listening to the gurus of the moment, they said the 10th Amendment is a dead letter or a truism, that reserving power to the states simply says the states have the power that they do. It's not an independent grant of authority. And newly vibrant, muscular advocates of federalism, again, at least 4 members of the United States Supreme Court, perhaps 5, saying no, there's an independent source of power that's an affirmative bulwark against the extension of federal power. Some debates apparently are never foreclosed. Some ambiguities from the beginning may last to this day. So, 2 of the 3 architectural principles are the separation of powers, defining how national institutes of government work and the authority they're given. The second is a sense of federalism, which is how geography helps to divide governmental power and prevent tyranny. The third is a set of limitations on the power of government generally and specifically, rights. Some of them are found in the body of the Constitution, as any of you who are historically minded know. Habeas corpus, the prohibition of bills of attainder, the abolition of ex post facto laws as a legitimate form, the right to jury trial in criminal cases, the protection of contractual rights against impairment by legislatures. Those are in the body of the Constitution. And many, maybe most of the people in Philadelphia believed that implicit in all of this structure was the prevention of tyranny and the preservation of individual rights. But quickly in the ratification debates, this became to be a running sword. And it seems quite clear in historical retrospect that the Constitution would have been ratified only by virtue of the promise that it would be followed by the submission to the states for ratification of a Bill of Rights, which of course happened 2 years later in 1789, going from something like 17 or 20 draft ideas of rights to the first 10 amendments to the Constitution, constituting that third bulwark, that third architectural principle, which is the establishment of affirmative rights as against the exercise of government power generally. Now, 2 qualifications. First of all, those rights to an enormous degree depend upon court protection, a resort to the judicial system. They are not, even though they're prohibitions and you take your oath of office not to violate them, they are not in many respects self-executing. They assume that there will be someone to adjudicate them. And that's where Article 3, at least in the federal scheme, comes into being. Article 3 establishes the judicial power. And that's kind of an American hybrid. You don't really find anything like what's in Article 3 about federal judges really any place before. Madison and several of his cohorts were deeply concerned about what they saw as the corruption of judicial systems because judges and kings owned them way too closely. So in many respects, the appointment of judges by the president, but with the advice and consent of the Senate, was meant to be the creation of a separate set of bulwarks against corruption or tyranny by the judicial branch itself. But as you also know, Article 3 doesn't establish all these federal district courts. It establishes a Supreme Court and gives Congress the authority to establish inferior courts, which of course the Congress has done with very substantial effort ever since. So that's number one, is the judicial system is needed to preserve these rights. The second became quite clear in a case called Barron versus Baltimore sometime in the early 19th century, but was clear essentially from the text in the beginning. which is that if you read the Bill of Rights, it says what Congress can't do. It doesn't say that the city of Des Moines can't do it. It doesn't say that the state of Nebraska or the state of Oregon can't do it. So by their terms, these rights are as against this newly created national government. The Constitution really doesn't speak directly to tyranny at the local level, which frankly is where most of us, most of the time, actually experience it. We had to have a civil war about that issue, among many others. And that's why a constitutional revolution really was wreaked, starting with right after that bloody Battle of Antietam, when it's said by some historians that Abraham Lincoln began to be thinking seriously about an Emancipation Proclamation and its political saleability in this very time. But as you know, the Civil War amendments, there were 3 of them, and they powerfully changed the relationship of state and national governments if the original foundational document had them. The 13th Amendment abolished slavery. The 14th Amendment, I'll just come back to in half a second. The 15th Amendment deals with voting power. These were officially, overtly, and by their language designed to protect people against state action. They were designed to protect against both immediate and foreseen abuses of power. And they provided a new source of congressional power outside of this 18 enumerated set of powers in Article 1 of the Constitution. Section 5 of the 14th Amendment provides for congressional enforcement of the rights that are granted there. And there are 3 rights, 3 major rights granted in the 14th Amendment, and one of them has 3 parts. So let me keep all the moving parts together if I can. The first of them takes the jurisprudence that began with the Magna Carta's Law of the Land Clause, which went through Sir Edward Cook's jurisprudence, which came to the founders as the Law of the Land and Due Process Clause, and established citizens' rights to due process as against inappropriate state government abuses of power. It established an Equal Protection Clause, and it established a provision, which Professor Ramon will address shortly, prohibiting states from infringing on privileges or immunities of citizens. What are they? We actually don't know what they might have been. There's a privileges and immunities clause in the text of the Constitution. But this whole new, very broad, very potentially thrilling set of rights that might be called our privileges or immunities. And in the slaughterhouse cases shortly after the Civil War, as you may remember from constitutional law, if you've taken it, or history if you have, the Supreme Court essentially gutted the meaning of that phrase in the 14th Amendment. But it didn't gut the meaning of the Due Process Clause, and in fact, the Due Process Clause of the 14th Amendment, in my view, has 3 meanings. The first is a set of procedural protections. As I say, government can do some stuff, but if it does it, it has to follow certain processes or procedures, give you certain rights of appearance or participation before it does so. The second meaning of the Due Process Clause, which came into view in some prominence really with the jurisprudence of Justice Frankfurter starting in about the 1940s, said, well, you know, how many of the original 10 amendments, or at least 9, the first 9, really apply as against the states? And the court said, aha, we think that through the Due Process Clause of the 14th Amendment, these things are kind of all due process. Justice Hugo Black said, yeah, they all go in. But that's not what the court did. Black was alone in that view, at least of total incorporation, or his view did not prevail. Instead, more likely, the Felix Frankfurter view prevailed, which is the Due Process Clause means that you can't violate things that are essential to a scheme of ordered liberty. So, is trial by juries, the First Amendment's free speech clause, are those? Yeah. The answer keeps being yes in a series of Supreme Court cases through the 40s, 50s, and into the 60s, and the revolution in constitutional criminal procedure that comes with the Warren Court. So the doctrine of selective incorporation proceeds through the vehicle, the textual vehicle, of the Due Process Clause of the 14th Amendment. That's the second meaning of the Due Process Clause. The third is more dramatic, maybe even more draconian, And that is, hey, the Due Process Clause of the 14th Amendment means government, you can't do some things at all, whether you surround them with a scaffolding of procedure or not. It's an affirmative limitation on the power of government generally. Well, the heyday of that view was all the way up into the New Deal court, but certainly through the 20s and 30s. Then we thought due process as a substantive matter was dead, had been buried, although there were already articles about its exhumation and reestablishment. But the notion that there is a substantive limit on what government can do that's commanded by the Due Process Clause is still a very current issue in our constitutional jurisprudence, and I say almost jokingly that at any one time it probably has 3 1/2 votes on the United States Supreme Court. You do see it, interestingly enough, very close to commanding majority in the punitive damages cases that the court has heard. You know, the tobacco industry that's attacked for injuring people who are smokers, and huge awards of punitive damages based upon what's seen as reprehensible conduct by the tobacco companies in marketing tobacco and so forth. And very large punitive damages awards. But the court always flirting, never quite to 5 votes, saying, you know, there's got to be some substantive limit on these bet the company kinds of verdicts in punitive damages. So the substantive due process language is alive and well, at least in some of the opinions in those cases. So that's sort of the trilogy of the meanings of due process. Some have waxed, some have waned, and some are sort of in this limbo as to whether or not they're really part of the meaning of our Constitution. How do we interpret this grand document, this arrangement of institutions? I think there are 5 ways, and 5 ways only. But, of course, these 5 ways overlap with each other, they intersect with each other, but here they are. The text, the history, the structure, precedent, and arguments about principle and policy. And in my great good fortune to have had 7 arguments before the United States Supreme Court, I can affirm from personal experience that the court moves rather facilely among all of these potential interpretive vehicles, with some justices, maybe most notably Thomas and Scalia, taking a very much stronger view about the proper or not proper role of text in history than others. The text. That very simple and straightforward. Justice Black used to say, what do the words say? No law shall infringe on freedom of speech. He says, is that a law? Yes. Is it speech? Yes. Can't do it. Others, Justice Oliver Wendell Holmes, modern philosophers, and first-year law students understand that words are slippery. They don't always mean what they seem to say. Moreover, there's a school of constitutional interpretation that argues over whether not only do you have to look at what the words say, you have to look at what they meant in 1789, according to the best dictionaries of popular discourse in the English-speaking world. And sometimes, regrettably for those who want to follow that holy grail, there's some things about which the text doesn't speak at all. Is, for example, the World Wide Web commerce? We don't know from the text whether or not Bill Gates's or anyone else's inventions really would have been comprehended by the way in which people thought about social and political and economic discourse in ways that government ought to relate to at all. So text can be both slippery, and it's subject to a deep debate as to whether or not, as language evolves, our understanding of constitutional language ought to evolve with it. I won't get much more into the debates about originalism here because this is an overview, but that's one area still of right controversy. The second is the history. If you can't tell from the text, can you then resort to the history? Well, that question is whose history? And just as the devil may cite scripture for his own purposes, so the devil sometimes can invent history for his purpose. Maybe the most prominent example of the use of history in the debate about its appropriateness, and quite ferociously contending the use of history, is in the interpretation of the Second Amendment, the Heller case and its progeny. Does the right to bear arms, is it individually based, or is it conditioned only on the existence of militias, which then give government a power to regulate it? You can read Heller, you can see the competing arguments, but that's argumentation form number 2, interpretation form number 2. The third is structure, which is if the history is silent and the words are silent, but you see a relationship of institutions, can you infer certain conclusions from that? And the answer is rather clearly, in the Supreme Court's jurisprudence at least, yes. Maybe most notable, in my view, is the notion of executive privilege. That is, that the president, the executive branch more generally, has the right to withhold from Congress key deliberations, communications, information, based upon the fact that if they are not held secret, they will imperil the existence of executive power or the authority and ability of the president effectively to conduct the executive branch's business as commander-in-chief or whatever other power the president invokes. The United States versus Nixon, which in modern times really recognizes executive privilege most starkly, overtly depends upon a structural interpretation of the Constitution. And maybe the court was thinking, although I can't prove this at all, and it may be blasphemy, maybe the court was thinking, gee, if the president has to cough up that information, then all of our draft opinions would have to get coughed up if Congress wanted to take a look at them, and we're certainly not going to let that happen. So the notion that there are key structural necessities for the functioning of each of these 3 separated branches is a structural interpretation. The fourth is precedent. Sometimes members of the court interpreting the Constitution will say, I don't agree with that, but I guess that battle was fought 10 years ago, 20 years ago, I'm not going to revisit it. It's part of the common law heritage of a court, which this Supreme Court richly has inherited in many respects. So, for example, people at least recently have not been re-arguing whether or not Miranda versus Arizona, has an underlying constitutional basis in the 5th or 6th Amendment, or whether it is simply a view about good police practices. Similarly, I watched Justice Rehnquist change his position on a punitive damages case. In successive cases where it was quite clear he was saying, fought that battle, lost it, and provided the 5th vote for a majority in a subsequent case. He didn't say he was following a common law notion of precedent and deference to stare decisis, but he rather clearly did. The 5th interpretive vehicle is the appeal to principle and policy. Where do we find that? The answer is all the time, actually. In those 7 arguments before the United States Supreme Court, I was asked about a piece of text of the Constitution hardly at all. I was almost never asked about the history of a provision. But I was subjected, as were all of the arguments that I ever observed and a great number of others that I've read and studied in preparation for argument. Members of the court are the most intensely Socratic court I've ever seen. They're actually more intensely Socratic than most law school classes. And they are a test of the principles. How far will this go? Where do you articulate a principle under which 300+ million people can live? That's what the court actually seems to want to know. It's intensely theory testing, intensely policy based, and that does not depend upon the perceived ideology of members of the court, in my experience. It's intensely based on what principle will be the best one under which we think we can make the United States work and function. Now, maybe those principles end up being highly ideological. There are many people who would say, of course, that's what happens. But in many cases, we see it entering into our dialogue. That's the broccoli case, isn't it, in the ACA? Well, if they can make you buy health insurance, can they make you buy, and nobody actually ever said eat broccoli, but that may have been the implication. That question actually emerged in lower court jurisprudence and was carried through, ultimately was asked by the court. I think there are answers and responses to it, but again, it's part of the theory testing approach to constitutional interpretation. What's your limiting principle, etc. You see it overtly, by the way, in the Eighth Amendment jurisprudence, cruel and unusual punishment. You know, the textual answer to the cruel and, is capital punishment or is torture cruel and unusual? The answer historically would be cruel, yes, unusual, no. Argument fails. But instead, the United States Supreme Court has by and large adhered to the notion that the Eighth Amendment will be determined according to a standard of, quote, evolving standards of decency, i.e. a notion of historical evolution overtly built into an interpretive principle. Perhaps quite unusual. That's certainly not a practice that's followed with all of the constitutional guarantees, but this one is seen as growing, not rooted in, limited by text or history, but rather an evolutionary sense of principle that may even raise such subjective, potentially, questions as what's decent conduct. So those are the 5 interpretive modes. They obviously don't operate in some exclusive vacuum. They interact with each other. But those are ways in which we make sense out of this document founded in 1787. Errors, traps, and pitfalls. I'm going to move quickly here and just identify them for your edification and reflection. The first of them was slavery. It was not abolished by the Constitution. Historical judgment and contemporary observers said they couldn't bite that one off and end up with a Constitution. They ended up with the quite monstrous notion, in retrospect, that some people were 3/5 of people. For purposes of representation and counting apportionment of congressional seats, which incidentally gave the slaveholding states enough power to maintain themselves and that institution for longer than it might otherwise have lasted. 25 of the 55 delegates to the Constitutional Convention, notwithstanding their semi-mythological status, were slaveholders. As far as the Constitution went, it prohibited the slave trade, but only 20 years from now. So not a noble, either in many contemporaries' minds or certainly in historical retrospect, and a terrible legacy, which stains the difficulties even of today's action. Second, ironically, is a time bomb that was an invention of its own time. That's the Electoral College. How did that get there? Well, the answer is sort of tied up with how the president got there. The convention was quite well advanced before they even changed their thinking from having 3 co-equal executives as president to 1. It went quite far before they figured, how are we going to select the president? Should the Congress do it? They didn't really like that notion. Should the state legislatures do it? It sounded like an invitation to chaos. There was, of course, no popular vote. And there were not, as it's hard for us in retrospect to remember, there were not political parties, at least not overtly stamped. So the notion that you could get an electoral majority through what Madison in Federalist 10 called factions was thought to be a really bad idea anyway, but really not fathomable. And so the Electoral College was thought about the way you finally get yourself to a majority of votes for a particular person as president. There was, of course, no universal suffrage then. There wasn't female suffrage then. It was property-based and limited. So the game has really changed. And, of course, finally became clear in the Constitutional Convention that probably the first president would be George Washington. That came as an enormous sort of sigh of relief to the delegates and probably accounts for the way the presidency is set up today. But the Electoral College is a ticking time bomb. It is a creation which, in a close election, might create huge problems of legitimacy and certainly is one of the, if not errors, at least anachronisms of the drafting. The traps of the Constitution. One trap is the United States Senate. We do not, by the way, have a democratic form of government because it apportions by state, not by population, for this very powerful advise and consent body, this very powerful one that has 2 votes per state. That was the New Jersey plan, became part of the later thinking of it. So was this really a way to save the small states, which is what they thought? Does it give us a pseudo-deliberative House of Lords? Or is it a check on popular passion, which is how the literature of the day reads? We don't want you to be too democratic. We don't want you to be too driven by plebiscite. So that's one potential trap. The second is the separation of powers an invitation to governmental paralysis? Is it an invitation for government by continuing resolution and political impasse? Are we going to go over the cliff in January because competing parties holding competing institutions can't agree? Europeans do not understand our version of separation of powers at all. They think it anachronistic, they think it's silly, they think it is horribly inefficient and may even lead to terribly bad paralytic results. You know, virtually every other parliamentary system, when the government loses confidence or loses a vote, the whole government changes. Not so here. Pitfalls. Well, we have rights gone wild. If you interpret the First Amendment so that speech includes money and campaign spending, and that persons include artificial persons such as corporations, have you set yourself up for plutocracy? A point which Professor Ramon, I hope, will address. The religion clauses speak nobly of free exercise of religion and prohibitions against establishing religion. And for all the litigation I've done on that point, I think they collide. I think it's very difficult analytically to reconcile the two religion clauses of the First Amendment with each other. Is federalism a great bulwark of individual liberty, or is it an abnegation of the notion that government can do necessary things at all? Is it sword or shield? Have we forgotten the legacy of the Civil War? And finally, missed opportunities. I can think of four of them. One is the guarantee clause, that is the authority of Congress to guarantee a Republican form of government. What's Republican? Representative government. It's very interesting. I have serious questions about whether the initiative ought to be used with such legal abandon if Congress chose to say states can't have that form of plebiscite that overrides the notion of representativeness that's part of a legislative scheme. The courts basically said that's a political question and ducked it, even though every elected official takes an obligation and an oath to support the Constitution. The Ninth Amendment referred to the enumeration of rights as not, quote, disparaging other rights that might be around. What are those other rights in the Ninth Amendment? We do not know. Griswold versus Connecticut, the contraception case out of Connecticut, is the only one that we really know of. The 14th Amendment's privileges or immunities clause. What if the slaughterhouse cases had been decided differently? And are there reasonable limits on corporate speech, or do we have Citizens United as the natural outgrowth of our inability to distinguish between the speech that we give to the Washington Post Company and the New York Times Company and the speech that we give to Polluters Incorporated United? We do not necessarily have good analytical tools for that. I will take a pause now and ask Professor Ramon if he would speak to a couple of those issues.
Thank you. As mentioned, I will discuss two specific issues that were mentioned by Professor Frohnmayer. The first is the 14th Amendment Privileges and Immunities Clause, and the second is the issue of corporate personhood and corporate free speech rights. So, first, as recounted by Professor Frohnmayer, the Supreme Court in its 1873 slaughterhouse cases decision held that the 14th Amendment Privileges or Immunities Clause does not make the Bill of Rights applicable to the states. And this, again, despite the fact that most legal scholars think that this was precisely Congress's intention in proposing the Privileges or Immunities Clause. That is, most legal scholars believe that this was a misinterpretation of the clause, and indeed, despite the court's ruling, over time, as we know, with the Due Process Clause, the court has begun a process of making Bill of Rights provisions applicable to the states. Again, a lot is at stake here. The question is whether states are obliged to respect things like free speech rights, that we will also discuss in a few minutes. Now again, the Supreme Court, over many decades, eventually did incorporate almost all the provisions of the Bill of Rights vis-à-vis the states. But still, despite decades of criticism of the slaughterhouse case's decision, and despite the fact that some of its essential holdings, essentially including the one that pertains to the Bill of Rights, has become moot thanks to the process of incorporation, the slaughterhouse decision was never overruled. Now, then came a moment in 2010 when many commentators thought that the court would overrule the slaughterhouse case's decision after 137 years. And that occasion was McDonald versus Chicago, the case from 2010, where the court was set to decide whether the Second Amendment is applicable and so is binding on the states as well. The conservative coalition that fought gun control and wanted the Second Amendment to apply to the states argued to the court that the amendment should apply not through the due process clause, not through the process of incorporation, that is, that it should not be recognized as a substantive due process right, but rather that it should be made applicable to the states through the privileges or immunities guarantee of the 14th Amendment. So, again, there is a revolutionary litigation strategy, if you will, that tries to revive, after 137 years, tries to revive the privileges or immunities clause and make it perhaps what it was intended to be when it was proposed by Congress, that is a source of serious fundamental individual rights. Now, this litigation strategy was supported by a number of liberal luminaries, for example, Lawrence Tribe of Harvard, one of the biggest experts in the nation for constitutional law. But it is clear why people like Lawrence Tribe, who is a known liberal, support this rediscovery, if you will, of the privileges or immunities clause. If you are a liberal and you like so-called unenumerated rights, then you have a good reason to try to revive a constitutional provision that has reached potential of discovery of such unenumerated rights. So if you like abortion rights, the right to refuse medical treatment, or the rights of homosexuals to sexual intimacy, you may be in favor of invigorating the privileges or immunities clause, again as another rich source of potential unenumerated rights. But of course the people who were running the McDonald litigation were not liberals, they were conservatives. And the question then comes up as to why this conservative coalition decided that it wants to support and advocate for the reinvigoration of the privileges or immunities clause. And the answer came out when, in oral argument before the Supreme Court, the lawyer that represented the Illinois Rifle Association was asked, what does he think these privileges or immunities are the privileges or immunities that are protected by that clause? And he responded by naming a few of those privileges or immunities, or constitutional rights, if you will. He mentioned the right to make and enforce contracts, the right to inherit, and the right to sell property. Now, all these rights, of course, are the same economic rights that the Supreme Court no longer recognizes under substantive due process. So if you remember, following the overruling of the Lochner Doctrine, the Supreme Court refused to recognize these economic constitutional rights and therefore allowed for the New Deal legislation to pass constitutional muster. Now these rights are of course the darlings of right-wing conservatives, many of whom think that the Lochner decision should never have been overruled. And so the push for the revival of the privileges or immunities clause, if you will, is, if you read the writings of the scholars, for instance, the conservative scholars who support this move, is really a move towards a renewed recognition of these economic rights that again allowed the New Deal legislation to pass constitutional scrutiny. In the end, no justice except for Justice Thomas, in fact, opted to go for a revival of the privileges or immunities clause. But as for the future, it is likely that the issue of economic rights would remain in the forefront of conservative jurists and the conservative agenda. And this brings me to the second topic that I will briefly discuss, and this is the constitutional rights of corporations. In its Citizens United decision from 2010, as you all know, the court invalidated a number of restrictions on the election campaign expenditures of corporations and unions. And it did so by relying on the constitutional free speech rights of corporations. And this brought claims that the seminal error in this area of constitutional law, the seminal error in the Supreme Court's treatment of restrictions on campaign finance, is the fact that corporations enjoy constitutional free speech rights. Now, I agree that the relation between money and elections is a scourge of American politics today, and that it is a major threat to our democracy, but I do not think that the root of the problem is corporate free speech rights. I think that corporations should enjoy constitutional free speech protections. Let's quickly consider the sort of corporations that we have here in America today. So first we have media corporations. Surely we all agree that the Constitution should protect the New York Times from government efforts to muzzle it, I would think. Then there are many non-for-profit corporations whose main business is in fact advocacy. So organizations like the Sierra Club, Amnesty International, the NRA, the ACLU, all these are organizations, corporations, that I also think should be constitutionally protected insofar as their free speech rights are concerned. And then, of course, there is lots of speech coming from for-profits corporations that I think is valuable and should be protected by the First Amendment. The Supreme Court recognized that even commercial advertising by for-profit corporations is constitutionally protected, and it recognized this in the 1970s in a case that invalidated a Virginia law that prohibited the advertisement of the prices of prescription drugs. Now, why would Virginia ban advertisement of the price of prescription drugs? Apparently, this was simply a protectionist measure that was lobbied for by the Virginia pharmaceutical industry that tried to keep competition out of its business. We want corporate speech to be protected because we want to make sure that we don't end up with crony capitalism. This is one reason why we want to protect even for-profit corporate speech. Now, the government has also tried to silence for-profit corporate speech in the name of imposing morality. So the Supreme Court also invalidated a ban on advertising the price of alcoholic beverages and a ban on advertising the availability of abortion procedures. These were also cases that had to do with the advertisement of for-profit corporations. And of course, the court also invalidated prohibitions on lawyers' advertisement. These were laws that tried to keep the good old boys network going, making it harder for new lawyers to enter the fray and to compete. So, there are good reasons why we want to protect the free speech of corporations. The problem with the Citizens United decision is not so much that it recognized that corporations have free speech rights, but rather the way with which it applied those constitutional free speech rights in the context of political election campaigns. These are my brief remarks for today. Thank you very much. Shall we take questions? Thank you.
We are at the end of it, maybe even beyond our appointed hour, so let me simply conclude by saying the Constitution is everyone's business. It's actually a great delight to see as many people come out to see and celebrate together, to think together thoughtfully. We could probably do no worse than to hope that the dreams of a 5th grader and a 3rd grader in Florence, Oregon, at a grade school would still be relevant. Clearly, it is our first law, and whether it still protects us is our job, not theirs. Thank you very much.